This morning, your panel consists of Judge Thomas Frierson to my right, Judge Chris Davis to my left, and myself, Judge John McClarity. Madam Clerk, are there any preliminary matters before we begin? In that case, will you please call the first case?
Jacob Thomas Cook et al. Versus Jefferson County, Tennessee et al.
For the appellant? I would assume you've already reserved your time for rebuttal if you so choose. Have you chosen it?
Not yet, Your Honor. 2 minutes.
2 minutes for rebuttal. It's up to you. Okay.
Sorry.
You may proceed.
Your Honor, my name is Arthur Knight. I'm from the Knoxville Bar. I represent the Jefferson County Board of Education, Jefferson County, in this appeal from the Honorable Judge Gass's opinion, where he found that the defendants were 80% at fault and awarded $260,000 minus the 20% that he placed upon the appellee for a total of $206,000. He's awarded discretionary costs as well. There was a preliminary motion that we filed saying that...
Just 1 minute, sir. Is the timer on?
Yes.
It's on, Your Honor, but I'm having a hard time with it.
Okay. Okay. You might go.
I've been going on for about a minute, Your Honor. Jefferson County was, this case has gone through several judges. It's 9 years old from the accident, and one of the court judges, one dismissed the bus driver, Harold Moody, under the Governmental Tort Liability Act as he is immune. Also, there was a dismissal of Jefferson County. Mr. Moody's order got filed with the clerk. The county's order did not get filed with the clerk, even though Judge Hooper signed it. And so I filed a motion to supplement the record thinking, and I think Judge Gass thought that the county was still in it. It's really just the Board of Education. The Board of Education owns the bus, and I think that's pretty undisputed. And we thought about doing an agreed order dismissing the county from the case. But anyway, I just wanted to bring that to the court's attention. This is an automobile wreck case that occurred on 11E in Jefferson County, Tennessee. I'll say plaintiff, counter-defendant Jacob Cook, who's the appellee, was traveling in a 2005 Nissan Altima. He was on his way to school. He was last day of school. He had to take a test to graduate. It was 7:45 in the morning. This was the first time he was driving his car since his grandparents had taken it away for being excessively tardy and mouthing off to them as punishment. It was a car on a salvage title, 145,000 miles. He was driving indisputably through a school zone, all the lights flashing on the bus that was driven by Mr. Moody, and, you know, in the signs that you see typically in a school zone. Now, 11E had 2 lanes, eastbound lane. Mr. Cook's going eastbound, 2 westbound lanes headed westbound, and the schools are to the right of the eastbound lanes. Mr. Cook testified that he was very familiar with the area, knew there were schools there, knows there's a hospital there, knows there's nurses there. It was foggy, visibility low, cold, dense fog, raining. He was going 25 miles an hour by his testimony on direct. He admitted on cross that he probably should have been going slower in light of the conditions when confronted with the Tennessee driver's license manual, which says, you know, if it's foggy outside, don't drive unless you have to. Well, He was driving, he was in the inside lane, in the fast lane, traveling to Jefferson County High School. He was traveling along. A bus driven by Harold Moody had just dropped off kids at one of the schools up on the right side of the eastbound traffic. He was following other cars and buses who were trying to exit and turn left onto the westbound traffic to get back to his house, and then he would come back and make his route again and pick up the kids later that afternoon. He stated, and this is a man with 35 years of CDL experience, he'd been driving a 2009 Bluebird bus for Jefferson County Board of Education for 1 year, and he did so afterwards. He testified that he was traveling. He looked left, saw nothing, looked right, saw nothing, looked left again, saw nothing, started going across, thought he could make it to the westbound lane, to westbound traffic. A lady with the SUV flipped her light saying, go on and go ahead. And he said as soon as she did that, a pickup truck came up behind her, and he had to stop, and his bus was in the inside lane of eastbound traffic 11E, where Mr. Cook was traveling. And he had to stop because if he went ahead and went forward, he would have impacted the pickup truck. That was his unrebutted testimony at trial. Plaintiff's counsel tried to impeach him on the fact that he did not say that in his deposition, but his answer to that was, you didn't ask me that question in my deposition as to, why about the pickup truck going around the SUV. In any event, an accident occurred. The Cook vehicle hit the backside of the bus. The bus was totaled, $55,000 in damages. The Nissan Altima was completely totaled. Mr. Cook had to be treated, he had surgery, broke his leg, had something like $68,000, $70,000 in medical expenses. I can't remember. The deposition of the doctor is in the file. We had an accident reconstructionist testify. He was there 2 days after the accident. They did not, the plaintiffs, appellees did not have an expert witness, did not depose the accident reconstructionist. He estimated Mr. Cook's speed based upon the crush damage to the vehicles, and based upon skid marks, and based upon photographs taken by Sherry Dodson, who was also there at the scene of the accident. And based upon the conditions of the road, he estimated Mr. Cook's speed between 46 and 53 miles an hour. At impact, he estimated the speed between 40 and 45.8 miles an hour. And then there's video from Mr. Moody's bus that shows the violence of the impact. And under cross-examination, which is all the appellees did because they didn't take his deposition, they posed a hypothetical. Let's say he was going 25 miles an hour and proposed a coefficient of the road. What would have been the impact? He said, well, they still may have contacted, but it would have been a minimal, wouldn't have resulted in any injury, and it would have been a minimal property damage to the Altima and to the bus. But, that's all speculation, and it's also contrary to the objective scientific proof at trial, which was testified as to Mr. Hutchinson. Now, I know that the standard is de novo with a presumption of correctness, as this was a non-jury trial, and it was pointed out that I did not criticize the ruling of Judge Gass in detail in the appellee's brief. I did not criticize Judge Gass personally. I criticized the findings that he made of 80%, 20% on the grounds that you have a young man who's going to school, who's been tardy, who has a radar detector in his car. He doesn't want to be tardy again. Has had his car taken away from him. He says he's doing 25, but then he says, well, maybe I shouldn't be going that fast. Scientific evidence shows him going almost twice that fast before he recognized the bus. All lights going on. He knew it was a school zone. He was familiar with the road. He's going to Jefferson County High School, and there's an impact, which you will see, if you go back and look at the video, you will see was a pretty violent impact We have, in contrast, we have a bus driver, an older gentleman who has a lot of experience in driving vehicles a lot longer than a school bus. And he said that, the accident was unavoidable. And the only person who had the chance to avoid any accident was Mr. Cook. Other people driving in the lane, the slower lane of traffic, the right lane of traffic on eastbound, was able to pass the bus easily. Judge Gass, one of the things I have a problem with, speculated that they may have been over into the shoulder part of the lane. There's no proof of that. There's no proof of anything of that sort.
Judge Gass, what did he determine the proximate cause of the accident?
Judge Gass determined the proximate cause of the accident was the presence of Mr. Moody's school bus in the inside lane of 11E, the inside eastbound lane of 11E, not the speed, not what we deem the sole proximate cause of the accident, which is the driving of Mr. Cook. And that is the issue that we take. That is the issue on appeal.
Am I correct that Judge Gass also make a credibility finding regarding the bus driver?
I'm sorry, Your Honor?
Did Judge Gass also make a credibility finding regarding the bus driver?
I did not see Judge Gass, in reading the opinion, make a credibility determination based upon his view of witnesses, of any witness. Certainly not of any of our proof of the bus driver, Ms. Dotson, or who's the transportation supervisor, or our expert. Nothing that he disregarded, and I know that you're free to that a judge is free to disregard an expert opinion if there is other lay opinion that you ascribe to, but here he just disregarded it, although saying an impact would have still occurred even under Mr. Cook's somewhat equivocal testimony that he was only going 25 miles an hour. So, this court, in our opinion, stands basically in the same position as Judge Gass, although this court did not sit there and listen to the trial. There were no direct findings of this person. I find this person credible, this person not credible. This is what I'm finding. Judge Gass was also familiar with the area. Everyone who lives in Jefferson County or Hamlin County is familiar with that stretch of road. I'm familiar with that stretch of road from going to Jefferson County and Hamlin County also. That's Andrew
Counsel,
Johnson.
excuse me for interrupting. Did the trial court make a determination relative to a department or board policy with regard to a bus being stopped in an intersection? And if so, how did that bear upon the court's determination with regard to allocation of fault?
I think that the court referenced the fact that, there's some equivocation about whether or not he violated policy or not, policy being don't drive in this situation. But there was, in that stretch of road, there are several other avenues that you can take to turn westbound onto 11E, and he said that he should have used an outlet to get to the westbound side, although, there was plenty of traffic on using the outlet that he did use, and it was the outlet that he used every day. So, yes, I guess the answer to your question is yes, in the affirmative, yes.
Thank you.
But I see my time is really low, and I did take a minute, but before the timer started, it is our position that the sole proximate cause of this accident is a young man who was speeding, who was trying to get to school. It was 7:45 in the morning. It was dense fog, low visibility, rainy, cold. He was driving on bald tires. In fact, I think his testimony was that he was getting tires for Christmas from his grandparents that year. It was his grandfather's owned the car. That's why Mr. McCarty is listed as a party in the property damage aspect of it. essentially, there's no issue that this was a school zone. He's familiar with it. There's no issue with the bus, lights, anything like that. He crashes into the bus, and a 2005 Altima disables a 2009 Bluebird bus, which is a large vehicle. It broke its axle. And that's our position. Thank you.
You have your time for rebuttal. Thank you, sir. Yes, sir. Will there be one or two arguments as far as on this side?
Pardon, Your Honor?
Will there be one or two arguments?
There'll only be one, Your Honor.
Okay, you might proceed.
Police Court, I'm Steve Terry of the Hamilton County Bar. Mr. Knight was correct for the most part in the facts. On this morning, it was right before school was starting. It was a very, very dense fog, very dense fog. That's undisputed. Every witness talked about the fog. Mr. Cook said that he couldn't make a turn at the light previous to where this, oh,
Yes, sir. Okay,
Sorry.
no problem.
I've got 40 minutes.
Go ahead. Okay, no problem.
I'll take it all. Now I've got 2 hours. Now I've got 2 hours. Ready?
Okay, go right ahead.
As I was saying, there was a very heavy, dense fog this morning. Mr. Cook testified that he was going to pick up his girlfriend to take her to school, and there's a light there where the hospital is, and he normally turns left, but he said the fog was so dense, even though he might have had the light, he couldn't see what was coming in the opposite direction, so he decided to go further down to a safer place to cross over. I do have a little bit of a problem with the way Mr. Knight's case has been framed. Let's go back to the supervisor of the buses there in Jefferson County. And let me interject here. We have no dispute whatsoever that the Jefferson County Board of Education is the proper party in this case. For some reason, the order didn't get filed, but we have no objection to them being taken out. We just didn't know the mechanism to do that in the Court of Appeals without just dismissing an appeal. So we don't have an objection to that. The supervisor of the bus drivers in Jefferson County, Ms. Sherry Dodson, in fact, she said Mr. Moody did violate school board policy, bus driver policy, by his actions that day. Number one, she said it's the policy that you're never supposed to be able to make a crossing across 4 lanes of traffic unless you can see 400 feet or about a football field in both directions and that it is absolutely clear. The next thing that she said is bus drivers are never supposed to stop in a crossing. Never supposed to stop in an intersection. Because if that bus is blocking something, she testified, and in fact, she said, if the bus doesn't fit, don't commit. So, number one, you've got 400 feet that he's supposed to be able to see in either direction and make sure it's clear. Number two, never stop in an intersection. Now, there's no dispute that when Mr. Moody pulled across and he stopped, the rear of his bus was entirely blocking the left lane of traffic. That's not in dispute. She also talked about her visibility when she got there about 15 minutes later. She said she could see maybe 10 feet when she got there and that she saw cars spinning around. She saw police cars spinning around because the freezing fog was turning to ice. Now, do we know if it was ice at the exact moment of this accident? No, we don't. But we do know that it was a wet, heavy, dense fog. Now, as to Mr. Moody, actually the court did find it had a credibility problem with Mr. Moody, and I'll tell you why. Ms. Dodson testified that the first time that Mr. Moody, and this is right after the accident, that the first time he told her about what happened, that he said a car suddenly appeared out of the dense fog and he had to stop in the intersection. Now that was right after the accident. He told her that. Then Mr. Moody gives a deposition about 6 months later, and he tells Mr. Brewer he doesn't remember how far he could see. When we get to trial, he said, well, he could see 250. And Mr. Brewer said 250 feet, and he said, I didn't say 250 feet. And so the court interjected and said 250 what? And he said, I don't know. And so the court says, so you don't know how far you could see? And he said, no, I don't know. So obviously, he did not have 400 feet of visibility, which is a violation of department policy. Number two, he stopped in an intersection, which is a violation of department policy. The court then asked him again, and he said he didn't know how far he could see. His story had changed 2 or 3 times at this point. And so the court did find that there was a credibility issue with Mr. Moody. As far as the accident reconstructionist, now, I do take issue with Mr. Knight saying that he testified under a hypothetical that Mr. Cook would have struck the bus anyway. That's not correct. Mr. Hutchinson testified on direct examination by Mr. Taylor from Mr. Knight's firm that Mr. Cook's vehicle would have struck this bus regardless, and that's using his own figures, using his own calculations. If he was going 25 miles an hour, he still would have struck this bus because the bus was blocking the lane of traffic. Now, you have to understand the way these accident constructionists work, the professional witnesses that they are. They plug in a lot of variables to get their desired result, and they are variables. For instance, one of the variables that Mr. Hutchinson used, skid marks. Well, he testified he estimated the skid marks because they were so light. What Mr. Knight was talking about is we did have a discussion about coefficient of friction as far as the pavement goes. And he estimated the coefficient of friction. He did not do a coefficient of friction test, which it's a guess. He said, yeah, well, I'm going to use this 0.4 coefficient of friction, and that's under his own analysis. And I asked him about that in cross-examination because without a coefficient of friction test, he assumed it was dry pavement. Well, we know that it was freezing fall and it was wet. So he used another variable, and that's that he plugged that in. Next, he measured crush damage to the Cook vehicle. And he said that wasn't an estimate, he measured it. But he didn't take into account that this vehicle had been totaled before. There had been previous damage to this vehicle such that it had been totaled and it was a reconstructed type. So we've got a variable on skid marks. We've got a variable on coefficient of friction. We have a variable on the crush damage to the vehicle. And all of that comes into play as far as calculating his speed at the time of the impact. Going back to what Mr. Knight said, Mr. Hutchinson testified on direct that Mr. Cook would have struck this bus anyway, or anything blocking that lane of traffic. On cross-examination, as a lot of these professional witnesses like to do, he started to hedge a little bit. And then at one point he said, well, he wouldn't have hit it. And that's when the judge interjected and he said, now wait a minute, did you not tell me earlier that Mr. Cook's vehicle would still have hit this bus going at 25 miles an hour using a 0.4 coefficient of friction? And he said, yes, it would have. So there's no question about proximate cause here. Their own expert witness admits proximate cause, and that's under his calculations. Now, the thing I have a problem with when these kind of witnesses is he can change the numbers to make them say whatever he wants them to. I'm estimating skid marks. I'm estimating coefficient of friction. I'm estimating, in this case, what the crush damage was because he didn't know what it was beforehand. So that all affects calculations of speed. just as an aside, keeps talking about bald tires. You know, tires don't matter. It cancels out in the equation. An expert showed me that years ago, that in the equation they use, it cancels out, and that doesn't matter in making these determinations. The thing is that the judge found that the proximate cause of this accident was Mr. Moody's bus blocking a lane of travel, which was in violation of the school board policy. He didn't assure that it was clear before the school board policy, and that the bus was there. And it was hard to see. There was also some talking with the expert about reaction time. People don't understand, you're traveling, let's say at 25 miles an hour, you're traveling 33, 34 feet per second. And you have a reaction time. It takes about a second to perceive a problem under perfect conditions. Perfect conditions. It takes about another second to react to a problem. So you've got about a 2-second lag there, because you've got to perceive a problem and then you have to react to it. Perception time goes up. If it's heavy glare, if it's heavy fog, if it's heavy rain, it takes longer to perceive what's going on. And so that's another variable that he guessed 1.5. I submit that it would have been more than that as far as reaction time. And I say all that just because there's no question of law in this case. These are questions of fact that the judge found, number one, a credibility problem. He gave some credibility to Mr. Hutchinson's testimony because Mr. Hutchinson said he was going to hit this bus. If he was going 25 miles an hour or even a little faster, he was going to hit this bus. But the damage might not have been severe as what Mr. Cook suffered. You know, Mr. Knight, in his brief, he said that there's no question about who was at fault in this accident. Well, we submit that the bus driver, number one, he had 2 options. Well, according to the court, he had 3 options, but he had 2 according to the court. He said if he determined it wasn't safe to cross, he could have turned right and gone down further to a point where it was safe to cross. Or, number 2, he could not cross. He said, does it matter that people might be lined up behind you, but with this heavy fog, putting safety at risk is not an excuse. The third option was he could have got off of his bus and called the police to come and help him get that bus across. And going back to Mr. Moody, the first we ever heard about this car and then a truck behind it was at trial. He didn't tell Sherry Dodson that. He didn't say that in his deposition. Now, he may not have been asked that question specifically, but the first we heard about a car and a truck behind it was at trial. And if you're familiar with this area, you've got about a mile of sight distance in both ways. It's a very flat area. And if there was a car and a truck coming in the opposite direction, Mr. Moody would have been able to see it. There's no question about that, if the visibility was there. I don't submit that the visibility was there and that he shouldn't have crossed because he couldn't see 400 feet in either direction. Ms. Dodson testified it was about 10 feet visibility when she got there. And so we submit that the judge was correct in its finding. It gave proximate cause of the accident to the bus according to their own expert. That was the proximate cause. No question about that. Severity of damage, he did credit some to the speed because he reduced the amount of damage by 20%. And so we submit that there's not enough here for a factual finding for this court to overrule the trial court. It's de novo with presumption of correctness, but it has to be sufficient to convince you that his finding was wrong factually, and we submit that it wasn't. Thank you, Your Honor.
Thank you, sir. You have your rebuttal.
I think I told Judge Frierson that Ms. Dodson did note violations of policy under perfect conditions. Was there 400 feet of distance, sight distance? to cross? No. Other people in front of Mr. Moody, which is unrebutted, said they crossed safely. Blocking, going to another outlet, going or calling the police or this, that, and the other, that was never warranted by any other vehicle that was crossing in the very same lane, in the very same area as Mr. Moody. Ms. Dotson did arrive 15 minutes after the accident. She is the transportation supervisor. Mr. Hutchinson, who was characterized by Mr. Terry as a professional witness to be paid to do whatever, say whatever we wanted him to say, actually investigated, talked to witnesses, looked at photographs taken by Ms. Dotson on the day of the accident of the skid marks, looked at the crush damage, looked at the vehicles. How do you explain a 2005 Optima totaling a 2009 Bluebird bus, which is huge? He couldn't have been going 25 miles an hour, and even assuming that he agreed with everything Mr. Terry said that it would have impacted anyway, he said no injury, minimal property damage. Look at that video. That video is the best evidence of the speed of that vehicle, and see the impact, how hard it was. It has to be, I mean, even a lay person could determine it was over 25 miles an hour, and Mr. Hutchinson determined it was more akin to twice that. Even Mr. Cook admitted that he shouldn't have been going that fast, and he was in the inside lane, and I see my time is over. So, anyway, thank you.
Thank you very much. We want to thank the attorneys for your presentation today. Your case now has been submitted to this court for resolution. You should be receiving our opinion and our ruling on this case within a very short period of time. But thank you again.